There was a brand new warning from special counsel Jack Smith this week. It came in the form of a filing, and it lays out his concerns that the disgraced ex-president's public comments could severely taint the jury pool in his 2020 election subversion criminal case. It comes amid a fight with Trump's legal team that is happening mostly under seal, so we can't see much of it. But what is clear and public facing because of this filing is that Jack Smith believes that time is of the essence when the defendant is posting daily about the case. Jack Smith and federal prosecutors are pushing back on a request from Trump's team for more time to respond to motions, calling it, quote, particularly infeasible given the pressing matters before the court, including the defendant's daily extrajudicial statements that threatened to prejudice the jury pool in this case. Joining our conversation is First Amendment scholar Ronnell Anderson-Jones. She is a law professor at the University of Utah. Ronnell, help us make sense of this. What can we not see, and what do you make of Jack Smith's concerns?
Well, the concerns are real ones, and they are evidenced every day with additional posts on Truth Social and other social media outputs from the former president that raise concern for prosecutors and raise concern for judges. The trial judge here is, of course, bound by the First Amendment, as all governmental actors are, but the First Amendment isn't absolute, and this is especially the case when it is in tension with other rights and liberties that are contained within the Bill of Rights. Trial judges here, in particular, have concerns about the obligation constitutionally that they have to preserve a fair trial and to make sure that there's an impartial jury. And because of this, we pretty routinely see orders from trial judges that are limiting speech that they think is designed to taint jury pools or to intimidate witnesses. And those sorts of orders are not only not constitutionally prohibited, but maybe constitutionally mandated. There's one kind of order from judges that gives rise to pretty significant constitutional First Amendment concerns, and that's gag orders against the press in its efforts to cover criminal trials. The court has made clear as a doctrinal matter that these are constitutionally suspect and that they can only happen as a matter of last resort. But when the order is against a party who has an obligation to litigate within the rules of evidence and who has an obligation not to contaminate the case with extrajudicial statements, the First Amendment arguments are much, much weaker. So the trial court here is going to want to keep an eye on this. You can see why Jack Smith is bringing it to the judge's attention. The judge is going to want to craft arguments and orders in a way that are carefully tailored to preserve everybody's broader First Amendment rights to engage in political speech. But these sorts of orders that are targeted and designed to safeguard the integrity of the judicial proceedings are pretty routine and wholly constitutional. And we may well see more of them coming our way, given the concerns that Jack Smith is articulating.